All right. Why don't we go ahead and get started then? Welcome everyone. Good afternoon. My name is Sarah Schrank. On behalf of everyone here from Nauman Smith, we want to thank you for joining us today for HR Issues Today, where the law meets practice. Here at Nauman Smith, we are very excited to be celebrating our 150th anniversary here in 2021, which we know is an incredible milestone. And we also know that we've gotten here by valuing and investing in relationships with our colleagues, clients, and the community. And we know that it's those relationships and the ones we're forming even today that will propel us for the next 150 years. One of the relationships we are very excited to be building upon is with Karen Young here of HR Resolutions. I should say fresh from the stage of the Society for Human Resource Managers National Conference. So thank you so much, Karen, for joining us today. We also have Benjamin Dunlap, who is our managing partner, and Jennifer Bruce, both here from our business and employment law practice group, who are going to be sharing the law or the legal side of the issues that we speak to today. A few housekeeping items, and then I will pass it over to them. This is a recorded session, as you may have just heard. Now, just so you know, the only people who will be recorded are our presenters today. And to make sure that you don't accidentally get recorded, we are encouraging you to keep yourself muted. It does pick up sound and it tends to go to whoever it hears. So please keep yourself muted, but we do encourage you to keep your video on. We would love to see your responses, your reaction. You can see each other, of course. If you do want to submit a question, which we would welcome and we encourage actually, please use the chat feature. We will do our very best to get to your questions during the session today, and I might help moderate some of that if our presenters don't see your question. If we do not get to it before our hour is up, because we know it will fly by like it always does, we will make sure to follow up with you separately. And finally, you will be receiving a link with the recording of today's session by the end of the week, along with some other supporting documents and the contact information of all of our presenters. So lots of opportunity to follow up and connect following today's session. All right, so today we are going to be tackling some of the issues most pressing to your businesses, and we're going to be talking through both the legal and the practical side of how you might be shaping policies or addressing these topics as you are hoping to attract and retain talent. So with all of that said, I'm going to turn it over to Jenny for our very first topic. She's going to get us started today.
Good afternoon, everybody. I'm Jenny Bruce, an associate attorney over here at Nauman Smith. I'm going to get right into managing your remote workforce. So 2020 and 2021 have certainly been big years of change for everybody. Over the course of this past year, many companies have found themselves at a crossroad in the face of a cultural shift, making policy changes, whether to attract new employees, increase employee retention, or manage employees' safe return back into the workplace in the face of the global health pandemic. And in the midst of this change, it's really important to reflect on all of these changes that have been made and think about our policies and procedures and understand from a compliance standpoint and from the practical standpoint how this affects not only our employees, but our businesses as well. So in the interest of time, I'm going to jump right into one of the biggest areas we've seen companies need to adjust and adapt on their feet this year, remote work arrangements. With the variant surging, a lot of companies have rethought and tried to formalize their policy on how and when to bring employees back into the office. A large trend this year is a hybrid work arrangement where employees are allowed to work from home and their presence in the office is encouraged on a regular basis, or some employees work in the office and some work from home. And this has been looked at as a good way to handle the uncertainty of the pandemic and some of the resistance of the employees to return back to the workplace. Some surveys of professional employees this past year, I read one this summer that said 40% of the employees that had been surveyed who were working from home would consider other employment if they were asked to work full-time back in the office immediately. I see a comment about my audio. Sarah, are you able to still hear me?
Okay, there we go. I think it might be when you were turning. So I think right now I can hear you. Do you want to go ahead and say something?
A bit there.
How is that? We'll try. I'll give you a thumbs up or a thumbs down, and we'll just manage as we go.
Okay, so some surveys of some professionals who are working remotely, they've indicated that they would rather seek other employment than return to the office full time. So I think a lot of employers are getting creative about their approaches on how to get employees back into the office, and this really requires us to look at the legal aspect of how can you get employees back into the office while keeping it fair. And certainly your decision is going to be made off your business's practical needs, but there's legal implications along the way. And you're going to have to look at employee requests on a case-by-case level as they seek exemptions from your requirements. So no matter what type of remote work arrangement you choose, whether you're bringing the employees back full-time or part-time, or they're staying full-time remote, you're going to face accommodations requests, whether those are requests for remote work or requests to make work from home accessible. And this brings a big consideration of the Americans with Disabilities Act, and whether an employee's request is a request for accommodation or just a request for a flexible work arrangement. Under the ADA, an employer must provide a reasonable accommodation to an employee with a disability, so long as the employee can perform the essential functions of their job and the accommodation does not cause undue hardship to the employer, which means a significant difficulty or expense. And the circumstances of the pandemic are certainly relevant to whether or not you can deny or accept a requested accommodation, especially a request to work from home. For example, if your business has lost their income stream entirely this past year due to the pandemic, that definitely would be relevant in determining whether there's been difficulty or expense in accommodating someone.
Jenny, can I interrupt and ask you to just adjust again? It was good for a while there, and then it started to get a little underwater-ish. Not that we don't all wish we were on a beach somewhere or lounging by a pool and, you know. Next days, Karen's reminding us her vacation is coming. I think that is better. Thank you so much.
And Jenny, one thing, if you don't mind, I want to jump in with the, you talk about the essential functions and the needs of the business. One thing I've always found from a practical standpoint is if I have an honest conversation with an employee about, here's why I need you to come back into the office. Generally, if employees understand the impact of their decisions and the needs of the business, I find them to be a little bit more realistic for me and a little bit more open to considering things. And having said that, as the employer, we need to be open to listening to the concerns of our employees as well and factoring that in as we're making these business decisions. But end of the day, it comes down to what does the business need to take care of their clients, customers, however you refer to that revenue producing source. We need to be sensitive to that. But if we make our employees aware, this is why. It's not just because we're saying, Sarah, you have to come back to the office because we have to go back to the office. Well, we've proven in the last 18 months, maybe we don't. But having that conversation, I found, can be quite helpful. That also leads us to uncovering, are there any ADA issues that maybe the employee was too afraid to bring up?
Right, I completely agree. And that's consistent with the employer's, your obligations under the ADA. When an employee raises a concern to you about they need an accommodation or they're requesting to work from home, you should engage in the interactive process with the employee and talk about whether maybe some other accommodation is available to them or, what their needs are and consider your business needs and work together with them to try to come up with some type of solution. And that can help your retention problems as well. So, moving into another large area for compliance concerns when you're managing your remote workforce is tracking the time of your employees who are working while they're working from home. Certainly for a lot of us, time on it become blurred, and this can raise concerns for your employees who are non-exempt under the Fair Labor Standards Act. Under the Fair Labor Standards Act, non-exempt employees must be paid overtime for hours worked over 40 hours in a work week and must be paid for all the hours that they have worked. And this applies wherever the work is being done, even if it's done at home. And with technology in the home, we have our laptops with us at all times. It may be tempting for your employees to do a little extra to get their project done or to log in early, even if you haven't asked them to. And the Department of Labor has issued guidance on this, on the employer's obligation to track hours actually worked for which the employee was not scheduled. And they've stated that an employer that knows or has reason to believe an employee is performing work, they need to count those hours as time worked and compensate them for that time. And because of that duty, it's really important for employers to have strong compliance practice and to enforce time tracking rules consistently across the board to avoid a Fair Labor Standards Act violation, which can be pretty costly. So going forward, no matter what your remote policy is, you should make sure your employees are tracking their time accurately while teleworking. The Department of Labor advises to have a clear written policy for timekeeping rules in this instance, especially for your employees that are working from home. You may also want to have them sign an acknowledgement of the requirements, and if employees are breaking this, enforce it accordingly. And it does come down to, as Karen's saying, communication with your employees about why it's important that they write down their time so that they know you want to compensate them for their time that's being spent while they're home. This may help with them feeling engaged with their work while they're at home and knowing that they're appreciated for the time spent. Another consideration to make while you're crafting your temporary or permanent remote work arrangement is how your employee is going to set up this workspace. Importantly, who's going to pay for it? Keeping any reimbursement requirements you may have under the ADA in mind, you're likely going to need to make a business decision on what type of equipment you want your employees to be using, whether that's a work issued laptop or, depending on your business, what materials they would need and how you're going to get those materials to them, especially with shipping issues during the pandemic. That needs to be planned out ahead of time. And again, communicated to the employees ahead of time. If there's also any requirements on how you want the environment to be set up, you'd want to communicate that clearly in your policies to your employees, whether they're temporary or permanent, so that they know what to expect. And also in that same line of thinking, the conversation about remote workplaces has led to a lot of questions from employers on what duties they have to keep the workplace safe and free from accidents when employees are working from home. A lot of employers at the beginning of the pandemic were worried they had no control over the home workspace, and they were worried about being responsible for employee accidents. And OSHA has addressed this and said that your responsibility for home-based safety is going to vary depending on the nature of your remote work. Under OSHA's general duty of care, all employers have a duty to furnish a place of employment which is free from hazards that are likely to cause death or serious physical harm. So you can see from that definition, typical office work, your responsibility is going to be little. OSHA has also made clear that employers don't have any duty to inspect the home office premises before they set up any type of home office.
I used to use that one. Pre-pandemic, I used to say, we have the right to inspect your workplace. And then I found out that no, we really don't. But I also want to jump in here with that standpoint. I don't think there is an issue either with you alerting your workers' compensation broker and your general liability broker that, hey, we've got a remote workforce. Just wanted to give you a heads up in case there would be any additional information that your insurance carriers might want to know.
Absolutely. And that goes for a lot of these legal requirements. Just because the bare minimum says, you don't have to do this, sometimes you may want to offer additional, you may want to consult your insurance, you may want to offer additional flexibilities, and that's okay too. And OSHA has said that you don't have to inspect the employee office conditions, and it would not hold an employer liable for the employee's home office conditions in that situation. However, if your employee is doing any type of manufacturing work, that would be a different situation, so that you would want to consult the rules a little more closely.
Benny, a question that I often run into is how do I tell people you can't be taking care of your toddler while you're working? Are there any, do we have any legal protections when it comes to that with defining the work area?
Well, that's a good question. I think with everybody being home and childcare issues have definitely come up this past year. I think that needs to be handled in the policy ahead of time, or at least communicated to the employees ahead of time, kind of expectations about um, their workspace and their environment and kind of their productivity and what's expected of them. I'm not thinking of any type legally of any type of laws about their workspace that may apply to that. I think it would come down to maybe managing their performance and what's expected of them under their job duties if they're falling below a standard of care maybe.
Look at that segue that I gave you without even realizing it.
I'll jump right to that section since you led me right into it. Remote work is nothing new, but a lot of employees have started working in the remote setting very unexpectedly this past year. And it's a good time to set expectations of how their productivity is going to be measured. And it's a good time for managers and companies to set policies about how their performance will be evaluated, especially when managers are monitoring them daily. And this communication can hopefully ease some anxiety of the employees and make the transition back into the workforce a little easier. So in the interest of time, I think I'm going to pass this over to Ben. And he's going to discuss regulating employee off-duty conduct.
Thank you, Jenny. Good morning, everyone. Thanks for joining us. This is a difficult situation that technology, as with many things, has been made more difficult. And it's always been, employers have always had the ability to discipline employees for certain off-duty conduct, for instance, criminal or violent behavior that's conducted while off-duty. But as far as social media has brought in whole new dimensions of things, and I'll dive right in with that employers' harassment and discrimination policies, which I hope that you all have, because that's really vital, can be enforced for conduct by an employee against fellow employees while off the clock. For instance, it really doesn't make a difference if an employee is being racially harassed or sexually harassed, during working hours, or if one employee is doing it to another through social media off hours, through Facebook or texts or emails. It's harassment that spills over into the work environment. It just can't be compartmentalized. So this type of harassment, is part of your overall policy, which, while I'm on it, I'll just state that a racial discrimination, gender, sexual harassment policy, it should be in writing. It should have clear people to report to. It should state clearly that there will be no retaliation for good faith claims. It should have a procedure for clear procedure for handling these matters. And part of that should be that it's not going to be tolerated either during working hours or after working hours. So another big one is whistleblowing claims. If an employer is violating the law in some way, such as OSHA standards, OSHA safety standards, or some other law, an employee who puts that on social media cannot be disciplined for that. And similarly, everyone thinks that I shouldn't say everyone, most people think that the National Labor Relations Act, the NLRA, just protects unionized employees. Well, there are certain areas where it also protects non-unionized employees. And one of them is discussing the terms and conditions of their employment. And so here again, if an employee is discussing his or her wages or safety policies and procedures of an employer, things like that, that can't be disciplined either. And there have been some, for instance, there was one case where an employer was ordered to rehire and provide back pay to a utility pole worker who was criticizing the safety procedures of his employer on Facebook.
Ben, a question, if I
Sure.
may.
Sure.
So with the social media, and of course with the what are called the protected concerted activities where they're talking about wages, terms, and conditions of employment, I get that. But what about if, for example, you have a daycare worker out in their uniform shirt and they are all kinds of inebriated and perhaps not acting appropriately, and you can clearly see who they work for? Is there a legal issue with having a conversation with that employee saying, do you think that was a good idea to post those pictures?
Not at all. I mean, in fact, that really goes to the heart of what the employer is doing. And people who are bringing their children to the daycare center want to know that it's responsible people working there. And if you have a picture of yourself being all inebriated online for anyone to see, on Facebook, then that goes against that. And that's another thing that you can prohibit. And any kind of, activities offline that bring the company into disrepute or embarrass it. However, you have to be really careful. Those kind of rules have to be narrowly tailored. And I know sometimes we all think government can be, very vague and make these rules and not give us any guidance, but the NLRA actually has some very good guidance, and we'll send out a link to it with our follow-up. It's the NLRA General Counsel Memorandum 18-04, and it has some really good examples of rules along those lines and policies that would be generally okay, ones that are generally not okay, and then those in the middle where you really have to be careful. And, for instance, an example would be that you can't prohibit social media messages have a policy that are, quote, offensive or embarrassing to the company. I mean, that's overbroad. I mean, you can, but it has to be more narrowly tailored. That would, bring the company into disrepute as to the services it provides to clients. Getting back to your example, Karen, that would be, an example, one that's more finely tailored to the needs of the company.
And Ben, Rose just asked a great question. Where is the line between personal social media activity and the affiliation to the employer?
Well, I think
Especially Rose, as HR, I battle that often with clients.
Yeah, and that's a very good question. And like most things on the two ends of the spectrum, it's pretty easy to see. Like if it's a president of Rite Aid doing something that everybody knows who that is, that's criminal or whatever, that's just going to be easy to say that's bringing disrepute to the company. But if it's a person who's maybe in the kitchen, a cook at a restaurant that nobody sees, that's, if they do something, it's not going to really, chances are, bring disrepute to the company. So I think if the person goes on social media, names the company and says this company is, this restaurant serves crappy food and it's way overpriced and I would never eat there, and they say that they're a cook there or something, then, yes, then you can make the connection. But it's not always easy to do. That's a good question. Moving on then, off-duty misconduct is another area. As I mentioned before, things that are criminal or, violent conduct, that can be, an employee can be disciplined for that because you don't want somebody who's doing that in the workplace. And if somebody has a history of doing that and it, for instance, if a person has a history of violent behavior and you have them then working with children, or, the elderly or something, you could be held liable. And it's in addition to it just being wrong. So, and this came up recently, a really good example where people who participated in the Capitol insurrection, there are a lot of those people got terminated for that. So as we said, that there has to be a tie to the business or reputation of the company. And another thing that's really interesting is that courts are increasingly siding with employers on dismissals related to racially charged conduct committed off duty. For instance, an employee posted on social media that people protesting police shootings should just be mowed down by motorists. And then that person was disciplined. I believe their employment was terminated. And then that person brought a lawsuit, and the court said, no, that's not protected activity because you're advocating violence. Political activity. Most unlike public employees, which are protected for their political speech, private employees are not. And so an employer can prohibit, during a campaign, any signs for or against a candidate or for or against various political measures or bills or things like that. The employer can prohibit any of that. And, an employer can actually go so far as to not hire people because of their political beliefs. I think that that's really dumb. You're shutting out a lot of good talent, but the people on the extremes, you might want to do that. If somebody applies to you and they're the local chapter head of the American Nazi Party, you may have second thoughts about hiring that person. So, but the one thing as far as political speech you do have to be careful of, and this comes up a lot more in public with the public employees, but you can't force an employee to take a political stand, to contribute to a campaign. Things like that are absolutely prohibited. The next thing that's really big right now is marijuana use. That under Pennsylvania's Medical Marijuana Act, employees cannot be discriminated against because they are certified to use medical marijuana for a condition that they have. But this gets into all kinds of really tricky questions with testing and what to do with the results. And just for a moment or two here, I'm going to turn it over to Jenny, who's done some more in-depth research on this and has some good advice.
Yeah, Pennsylvania's Medical Marijuana Act is a really interesting area to keep an eye on in this upcoming year. The case law is really developing and very uncertain right now and is likely to change how employers can regulate their employees' off-duty usage. Just to start, a quick primer, the Medical Marijuana Act prohibits an employer from terminating, discriminating, or retaliating against an employee solely on the basis of the employee's status as a medical marijuana user. The Act states that employers do not have to accommodate medical marijuana usage on their premises, but it leaves an unanswered question on whether when an employee fails a drug test for usage that was off-duty, whether the employer can discipline that employee for that failed test.
Jenny, I'm sorry, you were a little garbled there. Did you say employers do or do not have to accommodate?
They do not have to accommodate medical marijuana usage on their premises. But there's an unanswered issue there when an employee fails a drug test for usage that was off the clock or off duty. And it's even more complicated because marijuana is still a Schedule I controlled substance under federal law, and the Medical Marijuana Act says that employers subject to federal law don't have to do anything that would put them in a compliance issue under the federal laws as well. Just this past year, Pennsylvania appellate courts found that employees do have the right to bring a private cause of action against employers who do discriminate against them or terminate them in violation of the Medical Marijuana Act. So there is that potential there for a discrimination claim. But what is clear underneath the Medical Marijuana Act is that if an employee is under the influence on the job, you can terminate them. If they fall under the normal standard of care, you have the right to discipline them. And you also have the right to shield them from any types of jobs where safety is a concern. If they typically perform on heights, or if they, I see in the comments, CDL drivers, exactly. That would put you in compliance issues under federal law. If they fail, if they typically work in confined areas that may be a safety concern, you may be able to keep them from performing that job. So there are some areas where you can regulate them on the job. But the area that's unsettled under the law is their usage off the clock and what you can do about failed drug tests. So at this time, the best advice is to take it on a case-by-case basis and have a clear and solid drug screening policy. And then when an individual fails a drug test and they are a certified user, consult the case law at the time and determine how to proceed when it comes up.
Jenny, is there different interactive dialogue ADA paperwork to use for medical marijuana, or would it be similar?
I think it would depend on the reason for. Some of the medical marijuana users likely would have a condition that would qualify them for an ADA interactive process as well. Again, it depends on the individual. So it's a lot of case by case. You're going to have to see the facts of the specific situation. They're going to dictate how you have to handle that particular individual. But the Medical Marijuana Act is a unique situation that when it comes up, it's definitely worth looking into on its own.
Yeah,
If only these legislators would talk with us before they enacted this stuff and say, what are the practical implications here?
right.
I'm sorry, Ben, I cut you.
No, that's okay. I was just going to say along those lines that I think that best practice is in most situations that because marijuana for medical marijuana user, because it can stay in your system, evidence of it for days or even weeks, it can be a little tricky to let somebody go just because of, sorry, my light fell, just because of that. But so I think it's really good to tie it in with evidence of being, impaired because of that on the job. Now, there may be with special safety sensitive employees, such as CDL drivers, or with our employees, railroad operating employees, things like that the law may require, have additional requirements or more strict requirements for letting people go or disciplining them there. But I think in general, you should have evidence of usage coupled with, seeing evidence of an impairment on the job. The next matter is outside employment. And here, most companies, have no policies prohibiting moonlighting, and I'm not saying you should, but if you do, and I'm talking about generally for employees that, again, I had mentioned the president of Rite Aid, you might, something ridiculous example perhaps, but that he or she can't have a part-time job at CVS too, that would be, really bad in a situation like that. But, the outside employment policies should generally be limited to reporting to the employer just to make sure that there's no conflict. And here, with a fast food employee at Hardee's who wants to get a job at, part-time, another job at McDonald's, there's no conflict. But perhaps a salesperson for a medical device company, shouldn't be working for another medical device company, off the clock. And I think that a real point could be made that there's a competition problem there. And then the next matter is relationships. And some companies have anti-nepotism policies. Karen's making a heart. And here, I think you have to be careful with them because I think it's actually good to have a policy that you can't have, relationships between people in the direct line of supervision. And I think it's really bad for a supervisor to be dating his or her, person under them, employee. On the other hand, if you're in a big company with different departments, I just don't see any purpose in prohibiting somebody from one department who never sees or works with somebody in another department from dating. That's going too far. So you have to be careful about that. I think that these policies, the purpose of them, in my mind, is, to prevent, things that look bad, like family relationships. It's not good to have a husband and wife in a direct reporting situation because of the way it looks, but also because to help prevent sexual harassment. That if if a supervisor is, dating a person who reports to them, and then a sexual harassment claim is made, especially one that, well, I'll give you a raise or bigger raise if you, sleep with me, then that's obviously really, really bad. and so whatever we can do to help to, that those situations would not occur is very helpful.
And Ben, what I've found is I will have, again, I'm huge apparently on these honest conversations with employees. I will actually have a one-on-one conversation with each employee that has entered a relationship, and then I will meet with them as a couple, and I will explain to them, this is our unlawful harassment policy. I am so glad that you two met and that you seem to be having a great relationship. I hope that it goes in the direction that you both hope it to go into. In the unfortunate event, if it wouldn't, I want you to understand. And then I will actually have a follow-up conversation if and when that couple breaks up. I won't meet with them as a couple at that point, but I will meet with them one-on-one, and I will remind them about the conversation that we had at the start of their relationship, and I will review again our unlawful harassment policy and the reporting steps.
I think that's great. I mean, and unfortunately, where there's nasty breakups, as can happen, it's very easy then to make claims about something that may or may not happen, and that's unfair to both sides. So,
it's a fast way to get your ex in trouble.
Yes, it is correct. So my time's about up. So we're going to move on to all things COVID from Karen.
Oh, yippee! I get all the fun. So I am calling both of my attorney friends to help me out on this one. As we most likely all know, the president has just issued a mandate that if you have more than 100 employees, you must vaccinate or you must test weekly. So, and then to follow that up, OSHA has been directed to issue standards, not just guidelines, not just a recommendation, but standards. So taking out the political piece, and I'm going to ask Ben and Jenny to comment on this, but taking out the political piece and looking at the OSHA piece, regardless of whether we believe that the president has the right to do so, if OSHA issues that standard, then it's the law. And it is no longer a presidential mandate. It is the OSHA law, and we will have a duty to follow that. So when that was announced, and I was out in Las Vegas in the middle of the SHRM conference when this was announced. So trust me, it was a really, really big topic out there around the cocktail table. And everybody's like, oh, what are we going to do? We can't do this. And my big question to everyone is, well, who pays for the stinking test? And I think, again, legislators didn't ask us what the implications are of this. I believe the intent was the employee would have to pay for the test, and so that regular weekly cost would encourage them to get the free vaccine. But the reality of it is probably once it becomes an OSHA standard, where does the employer come in? We are required to provide the initial PPE for any employee. So are we required to provide the initial test? Well, if the test is weekly, when is it no longer initial? Because every week it would be an initial new test. So, Ben, Jenny, what are you hearing? What are your thoughts on whether the president can do this? And I know we're all in agreement that if OSHA issues the standard, hello, we're there. But if you could comment on who pays for the test.
Sure. And first of all, the standard has not yet been issued. It was just an announcement that the standard will be issued. So that is expected to come out early to mid-October from OSHA, and that it's hoped that it will answer a lot of these open questions. And part of this, which hasn't gotten nearly as much airplay in the news, was that in addition to the 100 plus employees, certain federal contractors have to also require their employees or workers to be vaccinated.
And that's with fewer than 100 employees, correct? If you are a federal contractor, congratulations.
Correct. And it's certain ones. I mean, it's not everybody. It's just if you fall into category. And those standards are coming out are due Friday. So that should give us a better standard, what OSHA will probably mandate in the emergency temporary standard. But, as far as who's going to pay for it, I think that it probably will be on the employee also. I agree with you, Karen. And one of the indications is the way that it's worded. It says, the announcement said that, quote, the emergency temporary standard will require all employers with 100 or more employees to ensure that their workforce is fully vaccinated, or require any workers who remain unvaccinated to produce a negative test result on at least a temporary basis before coming to work. So
semantics are wonderful, aren't they?
Yeah. So, so I think that an employer could require the employee to have those tests, and if he or she doesn't, they could be disciplined.
Well, it's on Facebook, so it must be true. Employers are buying cases of self-tests from Walgreens. Doesn't have them available for retail sale any longer because they are off the shelves.
Okay, and that just brings up a point that somebody said earlier, I believe, that just because there's a floor of what an employer can do doesn't mean they have to do that. If the rule puts the onus on the employee to do that, an employer could still provide the tests themselves. And just a couple more quick points before I hand it back to you, Karen, is another big question are how are the 100 workers determined? We have one employer who has a holding company structure, and under that there are that company. The holding company is over 100 employees, but the components of it are not. So will they be combined for purposes of enforcing this rule? It's unknown. Then also, what about part-time, temporary, and contract workers? Will they each be counted as one towards the 100? And volunteers. I mean, because it says workforce, I think that, if you have regular volunteers, perhaps even with the food bank, that there could be implications there, about requiring people to be vaccinated. So it's up in the air.
Yeah.
There's another question that's come up is, will persons who have had COVID be exempt? And the current thought is that OSHA will follow the CDC guidance, and my understanding is the CDC is saying now that they only see immunity from people who've had COVID for 3 months. And then finally, you must consider medical and religious exemptions under both the OSHA mandate and the ADA mandate. And for the medical, I would say that you should only accept from a licensed healthcare provider, not from somebody's aunt or whatever, or somebody's cousin in Trinidad, as has been on the news. And so that one's fairly clear cut. But the religious exemption,
apparently a doctor in Connecticut that is selling his signature for $100.
Yeah, that's been on the news about a doctor in Lebanon County too.
Okay, yeah.
And then finally, the religious exemption is probably the more difficult one, in that there's the only lawsuit I'm aware of on this in Pennsylvania anyway was down in Delaware County, and there the person, the plaintiff, was an employee at a Catholic, was Catholic, excuse me, and was an employee at a private school. And they had the policy for the asserted reason that to protect students and staff and to not have disruptions in classes and so forth. And the court said that a sincerely held religious belief is not enough, that you need more. And in this case, the court pointed to the fact that this person was leaning on his Catholic background, but the Catholic Church itself is encouraging vaccinations. And really, the only two churches that I'm aware of that discourage vaccinations outright, as opposed to just maybe certain members, are Christian Scientists and the Dutch Reformed Church. So if a person is a member of of those denominations, then they would have a pretty strong, I think, reason for religious exemption. And then you have to give them an accommodation, such as working from home, isolated work situation, enhanced use of PPE before they could be let go. Back to you, Karen.
Okay. Great questions in the chat also. Let me see here. Would a medical exemption or religious exemption still require that employees be tested weekly or if returned to the office? My response was that they're all great questions. I believe that would have to be the accommodation on the employee's part. And that's with the interactive dialogue. Remember, that's interactive. So a reasonable accommodation means we will accept this, and here's the accommodation. I'm not the attorney in the room, though, so they may disagree with me on that one. And then the other question was, if a company has more than 100 employees but only a handful work on site, is everyone still required to get vaccinated? And I'm hoping that the standards will assist with that definition of, is it 100 employees on site? Is it 100 employees off site? My experience with some of my clients, I actually have one client that is challenged by the owner of the company, chooses to not disclose his vaccination status, but I have a pretty good idea of what it is, because he has not been in favor of asking his employees. He has not been in favor of requiring any proof. He's kind of stayed away from it, and they've been, knock on wood, they haven't had anything go through the company in any of the departments. However, they are now starting to get correspondence from their customers that say, if anybody comes on site to do work, they have to be fully vaccinated. And he is getting more and more of those notices. So we are implementing now a policy and a procedure for, exemptions, accommodations, and the process. And vaccination status is actually going to become a condition of employment for new employees, unless, of course, there's an accommodation requested and that can be granted. So it's been interesting to watch that transition. I have another client who has actually offered $100 per employee. We are still only at 50% vaccinated. They have upped that to $500 now. $500 to get the vaccine. And they've also stated that if we do not get to 75%, it will become a mandate. So a lot of employers are looking at, and they are not at the 100 level. So I work principally with employers under 100 employees. So it's been really interesting to watch everybody's approach to the vaccine. So I kind of have my bullet points out of order. It probably makes more sense to go into the vaccination. Yes, you can ask for proof. If you have a safety concern and you've established a vaccination policy, if you have an incentive program for your vaccination policy, if you have customers that require vaccinated employees to service them, you absolutely may ask for proof. Now, the biggest thing I hear, and I'm sure the attorneys hear this also, it's a HIPAA violation. It's not. At least that is my layman's understanding. Ben is nodding his head. That's my layman understanding is it is not a HIPAA violation. I'm not getting anything about a protected health situation. I'm not getting any personal health information or diagnoses on these tests. And I have, frankly, even if it were, from a practical standpoint, you could approach it from this is a safety protocol. I have some people that are on a need to know basis. For example, human resources or the owner of the company or the dispatcher may have a need to know who is vaccinated. And while I love to trust my employees, I forget who said this statement. Ben, you might be able to help me out, but trust but verify. I do trust my employees, but by golly, I'm certainly going to verify. So,
Ronald Reagan, I believe.
was that who it said? Okay. I wasn't sure if it was him or Jimmy the Greek, and I don't know why I thought Jimmy the Greek. Probably many on this call that have no idea who Jimmy the Greek is, and that's okay. I own that I'm sage.
Just the one follow-up to your question, and it ties in with one of the other ones that that somebody asked was about requiring vaccinations, and the ADA requirement is that that it has to be job related and business necessity. And in certain areas, certain jobs, like a staff at a nursing home, for instance, that's easy. I mean, others, if somebody's working from home, I think you would have a very hard time, requiring that.
Yeah. Unless they come into the office.
Karen, yeah, you're absolutely right. It depends, and it depends on many of these things. Like the what you brought up earlier, Karen, about whether having tests would be reasonable accommodations to continue testing. I think it would be.
Yeah,
I think it would be.
Prove to me you can keep your coworkers safe.
Right. And and the thing about whether if you have more than 100 employees, but a lot of them or some of them work at home, my guess would be, hopefully the ETS when it's issued will clarify this, that if you have over 100, yes, you have a requirement, but only those who are working together. If they're working at home and they never come into the office, I can't see that requiring them to get out.
So Ben, I saw Sarah's blue dot, and in light of the time, I think I want to get to the last point, the masks. Our office recommends a best practice on masking in the office is tie it to the local transmission rates. There are 4 levels now. There is red, orange, blue and green, or green and blue. I don't remember them off the top of my head. But we've actually had one client mandate masks in the office. You know what? Actually, the Food and Drug Administration requires this of their USDA inspectors. So if you are in a high or the next level transmission rate, masking is required. If it is the next level, which is not low, but it's the, and I apologize, I should have been better prepared, but the 3rd level, if you are unvaccinated, you must be masked. And then, of course, if it's blue and everybody's clear, then it's a personal decision. So, Ben, Jenny, any comments on that?
No.
Okay. That wraps up everything you wanted to know about COVID, right?
Only it was that easy, Karen, everything we wanted to know. We do have one more point, and I'm looking at my clock, and we want to be very respectful of the time of everyone that is on today. I'm looking at my watch, I should say. Ben, can I ask you to do maybe the top points? Certainly we won't get to everything on this list, but for this final key, what is it that you would really want to communicate about employee handbooks? And from what I've been hearing and taking notes, it sounds like much of what we've discussed today are things that need to be in writing in some sort of communication. And I'll let you 3 speak to whether that's an employee handbook or not. I've heard Karen a little bit on this topic. But Ben, what would you like to share with people? Again, looking at 12:57, and we do not want to go much over our 1 o'clock deadline.
And I'm going to jump in because I'm really quick. If you have fewer than 4 employees, I honestly don't know if you need a handbook. That is a practitioner standpoint. But there are policies that you should absolutely have. Okay, I'm done.
And I agree with Karen 100% on that. I think that most companies should have a handbook. I think it's good to have policies laid out and so everybody's clear on what they are. But the important thing is, if you have one, you have to enforce it. You know, it can't be, you're not going to do it until somebody does something really egregious. You're not going to enforce a policy on late arrivals, you know, and you let it go for everybody, and then this one person, you know, you enforce it. That's really bad. Secondly, I think it's really important to have rules regarding exempt versus non-exempt employees, because companies get into a lot of trouble for that. And also, as far as I said before, it's really important to have an unlawful harassment policy, a written one. So.
All right. Any other questions? I'm appreciative of those of you that have put your questions into the chat room. Karen, Ben, and Jenny, I believe you got to all of the questions that were in the chat. There was one around whether masking or vaccinations would be mandated if you were under 100, what the implications were. I think you got to that in your discussion. If not, we will follow up specifically with that individual. But anything else that someone would like to put into the chat, final moments, or circling back to the keys that we've spoken to, anything, Jenny, Ben, Karen, that you would like to add before we wrap up today?
I'd just like to say quickly that there's some good general rules, and you heard a lot of advice from Jenny and Karen, and hopefully from me, about, you know, things that are good practices, best practices. But there's a lot of nuance in a lot of these things, and you really have to think it through. HR is a very difficult area in that it doesn't, there's not a lot of black and white. There's lots and lots of gray. So, you know, if you're unsure, you should really look into it.
Very good. Karen, anything you would like to add?
I'd just say, HR practitioners, please don't be afraid to reach out to your attorney. You know, yes, we know a lot of stuff, and a lot of us are attorney wannabes, but we're not attorneys. And quite frankly, penny wise, pound foolish, I think is how the saying goes. Give a quick call, send a quick email. If you're not sure, if you're pretty sure, but it's something that end of the day could cost your organization a lot of money, do a quick reach out. You know, just consult and double check and make sure. You are probably absolutely on track, but take the comfort of the quick email and saying, hey, just wanted to check in on this.
And I'll just say, thank you, Karen. And I would just say, in addition, that I'd much prefer spending 10 or 15 minutes talking something through with a client to avoid a problem than I would spending, you know, 20, 30 hours trying to resolve an issue that, you know, when somebody brings a complaint with the PHRC.
Very good. All right. Well, on that, thank you both so much. So just again, so that everyone knows, this was a recorded session. We will be sending the link out to you along with some of the supporting documents, some of the tips and tools that we've heard from everyone today. Thank you so much for joining us. We hope that you found some insightful pieces of conversation, maybe some things you hadn't thought through, or even just were able to see our team of panelists and hopefully look to connect with them following this session. So on that note, thank you all so much. We hope you have a wonderful rest of your week. Thank you.
Be safe and well, everyone.
Thank you.